I'm just used to sitting in Larry's seat.
You were
not
live.
This seat. Yeah. We're back on?
Yes.
Okay.
Okay.
There has been a motion, second, and agreed upon to come out of executive session. And I need a motion to rule on Board of Ethics complaint 2024 based on the Code of Ethics and Municipal Code 18 with regard to the Code of Ethics, Section 5. Do we find that Ms. Morton violated or not?
You can do it as, I would recommend you keep it generic,
Okay,
and that it's just whether there's reasonable cause for the board to proceed with complaint 2024-4. Without referencing any of the individuals who may have filed or who were named in it.
could I have a motion as to whether we believe there was or was not reasonable cause that 2024-4, the alleged offender violated code, ethics code and municipal code 18?
Motion as stated.
Is she found, what position? Is she found in violation of the law or not violation?
Not violation.
Well, hold on a second. There would be that would be the motion, and then there would be a second, and then discussion, if
Right.
any, and then a vote.
Okay.
Okay, we'll try this one more time. Could I have a motion to go into discussion with regards to whether there was reasonable cause to find a violation in the complaint 2024-4 against the Code of Ethics and Municipal Code 18?
Motion to go into discussion as stated.
Second,
Second.
all in favor?
Aye.
All righty, we will have a discussion with regards to whether there was reasonable cause.
If there's a need for discussion, otherwise you can just have a motion to vote on whether there's reasonable cause to proceed with that complaint.
After review of the materials and the discussion in executive session, do we believe that there's reasonable cause to proceed?
I apologize. Yeah, it seems that if, I'm not sure what you guys are doing. I don't know if the clerk of the board wants to recommend. But it's really just a motion that someone's going to put forward as to whether there's reasonable cause
Yeah.
Okay, there's no reasonable.
to proceed with complaint 2024-4.
I need a motion to whether or not there is reasonable cause to proceed with complaint 2024-4.
Motion to no reasonable cause to proceed with 2024.
Second,
Second.
all in favor?
Aye.
Any discussion before all in favor? No? All in favor?
Aye.
Sorry. We're going to go to this, and then we have a motion to dismiss the complaint 2024.
You can do that, but I think that
Does it?
I think you're all set.
Okay.
That's all.
So let's go into new business. The first item on new business is potential amendments to the standing rules of procedure for the Board of Ethics, effective March 21, 2024. And for the record, this is the first time we're talking about making any changes to the standing rules of procedure for the Board of Ethics.
They had a note for the annual review of the annual financial disclosure statement that we were talking about, because it said honor before April 1st. And I think at one point, we had down April 15th with a question mark.
Yes, April 15th.
Yeah.
So just to be clear on the record, what the portion you're talking about is paragraph 3. B,
Page 4
3B.
of 17.
Printed.
3B, and that would be
Mhm,
changing April 1st, April 15th.
mhm. We also talked about the procedure on page 8 of 17. And 9D, the 3 Is. Because remember on that one complaint, the person who actually did it was like
Yeah.
third party.
Yeah.
I don't know
We
how
did.
that would be worded.
What page is that on?
It's page 9 of
9 of
17.
17,
It's under D triple I.
triple I.
I don't know if that needs to be changed or if it's clear. Because we never had found out that he was the original author on that
Yeah.
one.
So what we're looking at is whether or not someone can file based on hearsay. What
Right.
they have
Yeah,
heard
right.
from someone else.
That's correct.
Right. We have two things from page 4 and page 9.
Yes.
Does the board want to add it to the complaint form possibly? Just a simple question maybe of if, is the information based on your personal knowledge or knowledge from some other
Doesn't it say that on it?
source? It may.
Yeah, I think it's that's where I had seen it that time when I saw it.
You must complete all, providing incomplete information. Every complaint must be sworn to and signed before a notary. You must submit complaint along with all sort of information, your position, so it's be on the end.
There it is.
Based
Yeah.
upon my personal knowledge.
Yeah, personal knowledge.
And I
That's
am
what it is.
signing
Yeah.
this.
Under the pains of penalties and of perjury.
Well, this is a good discussion, hearing because I'm concerned about hearsay. And I, you know,
Right,
in
yeah.
any environment,
yes, it's dangerous.
Yeah.
it's very dangerous.
Yeah.
Yeah.
Yes.
Yeah.
But I think Larry may, you know, whether is this, it says it, but do they read it? That's the issue. Maybe we could add
Can we
that.
make that in bold?
Well, either that or, you know, they're gonna read the instructions. You can only make a complaint if you have personal,
Personal, firsthand personal knowledge.
firsthand personal knowledge.
Yes.
Jim? I know, I've been doing that too.
Under the pains of and penalties of perjury.
But, sorry, there's a lot of scooting back and forth to page 9. Seems to allow another source or person. But it has to be documented. We probably should have had that on the one that caused the trouble, but I don't think
Yeah.
we.
Yeah.
Details.
Yeah,
No,
So it seems to allow it. Correctly,
It seems like it might be a fairly big burden to require personal knowledge. Like, I saw it, I heard it, I viewed it. We could add a question that the complaint form, was the information personally known to you or from another person or source? Yes, no. If yes, then state from whom.
yeah, that's probably a better idea.
If that might satisfy the concerns that the
Yeah.
board has.
Could we then add if it was or it came from another source? On the second page, could we add, is the source willing to sign under oath the information being submitted by another party is true to the best of her knowledge?
either that or you cut and paste,
Yeah,
Yeah.
D3, that little part that says if the facts were discovered from another source
Sure,
or person,
right.
state each and every source, line.
I gently suggest that the board does not want to make it too hard for someone to file a complaint.
Right.
right.
By the same degree, you don't want gossip
yes.
Right.
coming in.
Yes,
right?
that's our,
You got a
That's what-
fine
that's
line.
what
in
we're
the middle.
worried about, but
Yeah.
But those are the two kind of poles and you really want to be somewhere in the middle ground. I would suggest between, absolute firsthand knowledge. And I heard from this person that this person said from another person that
Yeah.
this person did this. I mean, at some point, it falls on the board in a way to do the work.
Yeah.
When that complaint comes in.
Like you said, are you, do you have direct knowledge of this? Yes, no.
If not,
If no, what is your source?
Mhm.
And then we can investigate further.
yeah,
Is there a way of saying that if not, would the persons from whom you heard it be willing to come forward or to sign?
well, that's what I suggested.
Yeah.
Yeah,
We
And
could certainly add that.
yeah. And if he says no,
well, because
then
then,
it's suspect.
right, I was gonna say, and then, you're discounting the validity of the
of the
claim.
And, right,
So I guess there's so many scenarios. I can imagine a situation where the source may not want to sign something. But once it's in front of this board and the board goes through these steps, it may get to the point where they issue a notice for that individual to appear in front of the board,
Mhm.
even though that person may not want to. So again, you may not want it to be so restricted
restricted, yeah.
that complaints that could lead to a potential violation finding are never properly reviewed or examined. And the current rules that you do have on page 9, which is section 5D3, seems to be sufficient to add that additional sentence to the complaint, because it does already say that if it's from another source or
Right.
person, state each and every source or person that provided and provide their contact information.
I think that, yeah, if we fulfill that obligation on the complaint form,
Yes,
then we
Yeah.
take care of that.
Yeah.
Because then we don't have to make a recommendation to change the
On it,
rules.
right.
because it was getting real sticky, and remember, we
Yeah.
didn't find out
And it wasn't until
the
later
actual
on when I
author
thought that he
until,
was,
yeah.
that made no sense.
I
We
think
went
that-
through so much time that we wasted on it.
I didn't want that.
One other process question that came up for the board would be on page 14. Under 5J subparagraph 3. When it says the board shall serve a notice to appear as provided in Exhibit G at least 14 calendar days prior to the fixed date of the investigation hearing. And the question was whether 14 days slowed the proceedings down and maybe
Oh, yeah.
was too much time, if
Yeah.
I'm recalling, and whether there was a desire to make that a shorter period of time
Yeah.
to be
Yeah.
able to keep an investigation rolling once it's underway.
Is 10.
Can we change it to 7?
I was thinking of calendar days.
Calendar days
or
would be-
I was thinking business days. I guess that is 14. calendar.
Say 7 business days.
I don't have a problem with shortening it. Because
Want me to update that to 7 calendar days instead of
Makes more
14?
sense. Yeah, 14 days is way too long.
And just so my intent will be then to do a red line version and to have that published with the next agenda for the next meeting,
Yeah.
so that the public and the members of the board have a time to review those changes. And then it would be on the agenda at the next meeting to approve or amend
Okay.
those modifications.
Larry, can you give us the institutional history as to why a person appearing during the investigation hearing isn't administered any oath or affirmation?
I don't know that there's any institutional history because these rules have not been in effect for that many years. The goal was to avoid some of the more formal requirements, I think, of having a hearing where individuals are under oath, to include bringing in a stenographer to do recorded testimony. That could always be created as an option for the board in the rules in a certain case to determine whether it would be sworn and recorded. Also, I think there was some lack of authority in the code of ethics that would give the board the ability to administer oaths. And that might be something that would have to be delegated directly from the Board of Supervisors
Mhm.
in order to be able to administer an oath. There's a provision in the county law that allows the Board of Supervisors to conduct investigations and take sworn testimony and issue subpoenas. It's not a provision that I've never seen the board use. I'm not aware of them using it historically. But I think there would have to be some foundation work that would need to be done probably before the board could lawfully enforce an administration of an oath.
Because we're not a legal authority. we're
Yeah,
an
we-
advisory.
You're only an advisory authority that issues advisory opinions
Yeah.
at the end of the day.
And we do have the option to do a recording already.
Yep, that may not be stenography. I guess it could be. It's the costs for having a certified stenographer to come in to take the transcript is pretty substantial
Substantial.
per witness. So. I think overall, when you look at the rules, because it's an advisory board, really the goal was to create different steps in the investigation of a complaint to arrive at recommendations for facts of what occurred and recommendations as to whether or not those facts marry up or equal a violation of the code of ethics, and not to necessarily meet the due process requirements of
Okay.
notice and opportunity to be heard that would exist if this board was issuing a final opinion that
Right.
would be binding.
Then do we have to change on 4 versus 14 days again, which is under 3, number 4, under D 4?
Number
Wouldn't that says 14 days again? Do we want to change that to 7?
Everybody keep it consistent.
Keep it to always be 7?
I'm sorry, where are you?
I was on page 4, under D and 4. I mean, we've changed the other one to 7 days. So would we not also change that to 7 days?
Yeah, that's that financial disclosure.
Because that's the disclosure. That was just stays consistent.
I got that. So paragraph 3 and 4.
Mhm. Yeah. Yeah, 3 and 4. Okay.
On page 7 of 17 is the only place in the rules where we address Freedom of Information Act, and it says that the board may treat a request for an advisory opinion as confidential, but the requesting parties shall understand that a written request for an advisory opinion and the resulting advisory opinion may be subject to disclosure under the Freedom of Information Act.
And there's also at the very last page, paragraph 6. Addresses the Freedom of Information law.
Page what?
The page 17 to 17.
Okay,
It didn't come up when I
there it
did
is.
this.
Or record submitted to the board of generative and subject to release.
Yeah, there was a request for board member notes. I saw that on one of the.
Yeah.
But all that, to me, I mean, any kind of notes I had, I shredded,
Yeah, mine too. Just
you know,
becomes a
decisions,
little.
because everything was made,
Yeah,
are deciding.
well, directly above that N.
Mhm.
Directly above the Freedom of Information Act on 17N, the release of the advisory decisions. They can publish on the webpage. Any decision made by the board.
Hmm.
Well, and my concern goes based on that most recent request. If you generated notes for the purpose of the investigation proceeding, which is under executive session,
Mhm.
where I have worked in the past, none of those were producible. Because they were,
So there are 2 different questions. The first is, does the record exist?
Right.
And then if the record exists, the second part of, I mean, this is a simplification, but the second part then is, is the record or some part of it subject to redaction or not releasable?
Right,
So it's definitely two steps
Two different.
in the process. So when there's a FOIL request that's received, the first step is determining if there's any records that are responsive.
right.
And then upon receiving those records, there would be a determination made as to whether those records are releasable or whether redactions should apply to some part or all of the document.
And we don't have any retention requirements under this law.
No.
No, okay.
Not that I'm aware of.
I looked, what,
Yeah, I mean, because it's advisory. I'll go back and double check the New York State rules on retention, which the county of Warren has adopted. And I'll let you know at the next meeting on retention period.
I definitely would be interested in any public comment on this, but it seems to me that my personal notes, which are not entered into anything, are my personal notes. I don't see, because those are not entered into any sort of record. How is that FOIA-able?
By writing it, you create the record. The issue is whether that record is released or if it's redacted in or withheld in whole or in part.
Which again, for the public and realistically, then is encouraging me not to record anything.
that's right.
They may be doodles or memory, mnemonics for me to remember what the heck we're talking about. I've never been asked for my private notes for anything. So I have a bit of trouble.
Not that it would be necessarily releasable. But once the record is created, it exists. And once it exists, the issue then is whether the document is subject to release under FOIL or if there's an exception or exemption that applies to it.
Is it because the creation of the document was done during the session as a member?
Yes. Same with email. I mean, they all become official records of Warren County. All the emails that come and go get retained in an archive for a period of years that can be searched and are searchable. And we regularly receive FOIL requests to obtain documents from the email archive. Could go back a couple of years, depending on what the request is. So, if there's any one-on-one conversations anyone wanted to have about FOIL, I'm more than happy to have those outside of the public meeting. But if there's any other questions, I'll do my best to kind of answer them off the cuff. But again, big picture is if you create the record, it's a record. The issue then becomes whether or not that record is something that would be released under the state statute. And because of the advisory nature of the board, there's not a lot that is releasable as a general concept and rule, or at least I think a more affirmative way to say it is that many of the records would be withheld from release because they're advisory in nature.
Okay.
So as we're on page 17 of 17, unless there's any other discussion items, I will do my best to follow what we talked about today to update, provide a red line version prior to the next meeting that the board can then consider as part of their agenda at the next meeting.
Okay, we'll do our second public comment and call for public comment and privilege of the floor. The next meeting date will to be announced.
There was the second, number 7 there. That's a different thing, right? The discussion.
Items, the potential recommendations to modify code of ethics and annual financial.
Was that to bring in alignment the relationships between what people need to disclose?
I wasn't sure what the conversation might entail on the rules and whether that might have some impact on the code of ethics. Part of the code does provide for the Board of Ethics to make some recommendations if there's any adjustments that need to be made or recommended to the code of ethics. I would gently suggest that we can't defer that until maybe we have the full board present. To include the chair who wasn't here because of a conflict of interest with the matter that was being worked on today.
Hearing no public comment and privilege of the floor, and next meeting date to be announced, take a motion to adjourn.
Motion to adjourn.
Second,
Second.
all in favor?
Aye.